Hi class, this is Alyssa along with Jaime, Andrea, Natalie, and Marie, and for our final group project, we will be going over Chapter 6, International Employment Law, Labor Standards, and Ethics. Thank you. The topics that we will be going over today are comparative law, termination and reduction in force, personal data and protection, anti-discrimination, immigration and visas, and intellectual property.
First, we are going to talk about comparative law. In the next slide, we have a little YouTube video explaining what is comparative law.
What is comparative law? Comparative law is the study of laws and legal systems in other countries. This form of law describes, analyzes and compares foreign legal systems, and is increasingly important in the trend toward globalization. It is essentially an academic study that both separately describes different legal systems and pits two or more legal systems against one another to determine the differences. Since French social commentator Montesquieu wrote his book De l'Esprit de Lois, or The Spirit of the Laws, on the importance of comparative law, several branches of this study have developed. These include constitutional law, civil law, commercial law, criminal law and administrative law. These fields of comparative law enable justice systems in every country to attempt to perfect their own legal system, to attain a greater understanding of the world and values outside their own country and, in some cases, aid in the different initiatives that work toward the unification of legal systems. Outside of a knowledge standpoint, comparative law is essential in improving and maintaining communication between different legal systems. Other than providing a structured means of intellectual exchange, it is also helpful in shaping foreign policies in different countries. This aids in streamlining the legal process for global businesses and the treatment of border-crossing criminals. While comparative law can and does compare the legal systems of two or more countries, the breakdown of legal systems is often much more complex. Countries of the world are typically broken down into families, though classification of these families varies. The oldest grouping in comparative law broke down the world into 7 families, including the French group, the German group, the Scandinavian group, the English group, the Russian group, the Islamic group and the Hindu group, with each of these groups encompassing a number of countries. Comparative law also often groups countries by their ideology. The simplest form of this puts countries into one of 5 families: Western law, Soviet law, Muslim law, Hindu law and Chinese law. Another version of this grouping focuses on both ideology and the history and sources of the laws in use. This form of comparative law groups countries into 6 categories: Roman, German, Anglo-American, Scandinavian, Far Eastern religion. With the increasing trend toward globalization and more countries moving toward industrialization, comparative law provides a gateway to understanding and cooperation. It not only allows individual countries a look into the workings and beliefs of their neighbors, but it also provides an overall look at humanity as a whole. From its inception in the 1700s, comparative law has continued to grow into one of the most important and relevant legal and humanities studies in the world.
The goals of comparative law. The overarching goal of comparative law is the accumulation of knowledge. The first goal of comparative law is to perfect a legal system. Comparative law is an école de vérité, furthering knowledge in order to produce the foundation for growth and supply of solutions, enabling legal systems to see where they can improve by providing examples. An important aspect to understanding a legal system, as David and Brickley put, it is to understand the internal matters of legal technique. Along with this, the external matters must be considered, such as political, philosophical, and economical considerations. The second goal of comparative law is to explain legal diversity. Legal diversity can be observed when studying almost any group of legal systems. There are systems which have similarities. They may have the same institutional structure. They may have similar roots, but the path each system has carved out over centuries of existence will involve many divergences. In order to explain legal diversity on a smaller scale, grouping together legal systems as Ziegler and Colt did into families would produce groups of legal systems with a similar heritage. For example, a group making up a legal family due to their basic in Roman law, such as the Romano-Germanic family identified by David and Berkeley, could be evaluated in terms of how they develop the system since then. Themes of the contemporary discipline of comparative law. The actual comparison of legal systems, the discovery, explanation, and evaluation of similarities and differences is only one of several themes of the contemporary discipline of comparative law. A second theme concerns the influence between legal systems, especially the reception of law, whether of individual legal institutions or of entire legal systems. With regard to Europe, this encompasses on the one hand the influence on European private law of different legal systems, Roman law, the law of member states, the law of non-European states. On the other hand, it includes the transmission of European law to non-European legal systems. A third theme of comparative law is the development of a general theory of law. Here, comparative law functions as the discipline which attempts to understand the various legal systems in their totality and in their relationships to each other, without necessarily trying to avoid or minimize the existing differences between them. Comparative law methodology. Comparative law must have a sound methodology to operate as a legal science. There are four critical paths to comparative methodology. The first part is acquiring the skill of a comparativist in order to evaluate law clearly, objectively, and neutrally. The second part is evaluation of the law as it is expressed concretely in words, action, or orality. We can refer to this as the external law. Once we get to an understanding of the law as it actually stated, we can move on to the third part of the methodology, an evaluation of how the law actually operates within a culture. We may refer to this as law in action or the internal law. Law in action is quite important, even to Western culture, as often the words in the text take on a different meaning as applied. Law in action is even more critical for non-Western culture, as here the law may be more a result of tradition, custom, or orality. To do this, we need to examine the underlying substructural elements within the culture that drive and influence the law. After we have evaluated the law as it stated and the law in action, we can assemble our data and conclude with comparative observations that can shed light on both a foreign and our own legal culture.
Now we will be talking about termination and reduction in force.
Termination and reduction in force. Employment is protected with a contract that interprets the terms and the conditions of an employer's actual employment. Employment at will. The employer with a full expectation has the right to terminate an employer at will. An employer has the right to quit at any time, no matter the reason. Termination. Termination cannot be done on the grounds of health and safety, pregnancy, or maternity, asserting a statutory right, union activity, or due to someone's gender, race, religion, or disability. Most countries' rights to terminate, lay off, reduce, restructure, move, outsource, or subcontract work is constrained. Reduction in force. They require notice and consultation. Most countries require payment to employees, especially when a large number of layoffs are made, to business closure, workplace closure, diminishing economic needs to work. All of the above are required notification and a possible payout. For most countries, they find it difficult to terminate based on downsizing, relocation, and significant layoffs.
The next category in comparative law will be personal data and protection. Personal data and protection, privacy, is an increasing concern that is present around the world, and it involves the sharing of distributing private, public, or firm information. This issue has significantly increased due to the high spread of the internet, making global communication so much easier. Privacy protections have been put in place when data is being shared, especially between Europe and the United States, to be reviewed and fall within compliance. This is to ensure the safety of data being accessed and to avoid any hackers or disturbance of obtained data. The privacy protection policy that Europe has is called the GDPR. Europe has this protocol in place, and if the US were not to comply, they would lose rights to do business in the European region and are also liable for any fines and misplacement of data without the privacy protection. Along with transferring data through protocols, search engines and the wide use of social media do not unfortunately contain the spread of the data. GDPR stands for General Data Protection Regulation. In the image below, it describes the main objectives of this data protection regulation. The main objective is to reinforce, which is substantially strengthen the rights of citizens by giving them more control over their personal data. Creditability, to increase awareness of data regulation through a system of penalties. Establish, introduce new rights for Europe nationals. And empowering, empower the actors involved in the data.
Our next slide is over anti-discrimination. Anti-discrimination. It is to be opposed of any kind of discrimination towards a certain group of people that represents a particular race, age, gender, disability, education status, or religion. The purpose of the Anti-Discrimination Act of 1977 is to render any and all unlawful action in certain situations and to promote equality. The Equality Act is similar to the Anti-Discrimination Act because both are defending the right of equal opportunity, but they have different meanings. The Equality Act ensures freedom and equality for all humans who are born in the United States, while the Anti-Discrimination Act defends equal opportunity to anyone living or working for this country. Anti-discrimination example. Many, if not all of you, have heard a lot about the Human Resource Department at work who carefully focuses on equal opportunity of employment to current and future employees. The Human Resource Department is divided into many different branches: payroll, recruiting and staffing, labor relations, benefits and compensation, training, and human resource compliance. Each of these branches can specifically handle the situation of an employee. In this case, a human resource representative must handle a situation that is over a discriminatory act. For example, let's say an employee reports to HR that their supervisor is treating them unfairly because of a physical disability they have. This employee states that they never have a chance to work in the front to speak with guests and is always scheduled to work in the back because the supervisor does not like that the employee has a stuttering disability. At this point, the employer is accusing the supervisor of a specific action and it must be investigated. So, exactly how must we handle this? Well, first, we must ask ourselves, is this a true act of discrimination? Does the supervisor have a history of discrimination? Does the reporting employee have a history of accusing towards others? What action must be taken to best help the work environment?
Our next slides will be over immigration and visas. Immigration and visas. Every country has control over its definition of citizenship and immigration that is allowed into its territory. A country's attitude about immigration varies according to its particular employment needs at any point in time. Every country requires these whenever a foreign person is transferred to or takes on a job in its country for a period of 6 months or more, and that includes work permits and visas. The amount of time to process and the requirements needed to acquire a visa vary from situation to situation and country to country. Gaining approval of various visas is often complicated, time-consuming, and expensive.
Here we'll be talking a little bit more about immigration visas. HR's tactical role consists of anticipating roadblocks in visa application, being aware of application procedures in different countries, complying with record keeping and tracking of visas. The EU creates special cases in terms of visas because of treaty provisions for free movement of labor within its members' countries. Having a valid identity card or passport is sufficient as EU nationals have the right to residency in any EU host country.
The following slides will be over intellectual property. What is intellectual property? Intellectual property are forms of employee creations such as patent innovations, discoveries, trademarks, geographic indications, industrial and product design. Inventions and intellectual contributions which are a result of individuals' employment are considered employers' property. Trade secrets, product, process technologies, and patents are either filed for legal protection or protected through non-disclosure agreements with other employees. Training materials and product manuals that employers develop for employees' use are copyrighted in order to protect them from outside use. The WIPO, also known as World Industrial Property Organization, is an agency of the UN responsible for the promotion of the protection of IP worldwide. They administer the multiple international treaties and develop conventions for its member states. The PCT, known as the Patent Cooperation Treaty, reduces the duplication of efforts with regards to patents in different countries and allows for filing in a single national office. The Berne Convention provides national and automatic protection, and the Universal Copyright Convention provides only national protection. National treatment, which is the minimum protection, means that local law applies to all copyright infringements that take place within the country, even if the original work was created elsewhere. The automatic protection means local law applies even to works that have not satisfied the country's required formalities.
Thank you for watching our presentation over international employment law, labor standards, and ethics. If you have any questions, please leave a comment below.